Hello, part 4 of our series, Why You Don't Need a Lawyer. By now you realized that the title is sort of a challenge. And here we see the California Association of Realtors talking about a short sale under the section of seller's continuing liability on the debt. While deficiency judgment laws in California apply to foreclosure proceedings, these restrictions do not necessarily apply to the lender's ability to pursue a borrower for unpaid balance on a loan following a short sale. A foreclosure is an involuntary legal proceeding. A short sale, on the other hand, is a consensual agreement. As a result, some lenders, in negotiating a short sale, will want the owner to sign a note for the balance of the unpaid principal. Other lenders will release the lien only, but not forgive the underlying debt. Some lenders will reserve their rights. Thus, while other lenders retain the right to pursue a deficiency, following a short sale becomes a negotiable term for each sale. So, if you are a realtor and you don't want your sellers advised of the fact that these terms are negotiable, you're going to tell your clients you don't need a realtor to negotiate you don't need a lawyer to negotiate your short sale. You don't need a lawyer to review an approval letter. And by the way, these terms, release of lien, release of mortgage, are enough. By the way, I'm also a lawyer in a mortgage theory state. The mortgage is also the lien in that state. Now, I know we can make the arguments for Californians about a mortgage being the loan in California, but I can tell you from experience, if you allow your short sales to close with ambiguous language, especially now on seconds, and or missing language, or anything short of good language, you're running the risk of the bank coming after you for the remaining loan balance. And I will tell you, the banks are getting smart. I'm seeing people who have good salaries, consistent salaries, or we're seeing people with government jobs, or we're seeing people with good assets. They are starting to get the collection letters. They're starting occasionally, still rarely, but they're starting to see lawsuits on these deficiencies. So if you care about your future, if you don't want to, and other people, they've been tortured after short sales with having an open loan, especially on a HELOC. If you go down here, Part C, they talk about junior liens and HELOCs. There's a HELOC. You do a short sale and you don't get that HELOC closed as there is in writing with proper language, you're going to have to call them because you're going to be looking to move on with your life, even a few years after your short sale, and they're going to say, oh no, you've got an open loan. We've been digging your credit once a month or every other month because you've got an open loan balance that you're not paying on right now. We've seen it. I have neighbors in Carlsbad who have that problem with HELOCs from other parts of the state and other states. So yes, if you are not concerned about your future, you're not concerned about getting Bank of America to change their language, then you don't need an attorney. But if you do want Bank of America to change their language to release the remaining loan balance in writing, if you would like that in your approval letters so that you can get done with your short sale and move on with your life, then you should speak with an attorney who can show you that he's changed the language, who knows how to do it, who knows the legal tools available, who does not claim to do it every time, but knows how to do it a great deal of the time for people with 580B protected loans, and occasionally when it's his own files in his brokerage because he set it up the correct way from the beginning. Thank you, John McConnin, UpsideDownRealEstate.com.